Welcome everyone to our webinar on the newly passed CDPA. I'd like to start by introducing Marie Kulbeth. She is the General Counsel of SixFifty and the co-director of BYU Law X, a legal design lab dedicated to solving access to justice problems. Before SixFifty, Marie served as an assistant dean at BYU Law School, where she built a diversity recruiting program. She came to SixFifty to prove the concepts she teaches in Law X. Law can be less complicated and it can be more equitable for both companies and individuals. Austin Smith works on data privacy issues for SixFifty, focusing on the CCPA, CPRA, and the GDPR. Before joining SixFifty, he advised companies ranging from tech titans to small startups in his work at law firms. Austin also worked on Capitol Hill, briefing members of Congress and their staff on privacy issues. Austin graduated from the University of Virginia School of Law in 2013. I'll now turn the time over to Marie and Austin.
Thanks, Jesse. Welcome to the webinar today, everybody. We're excited to talk about a brand new law that literally just passed. We are going to sort of have a back and forth format between Austin and myself today. Austin will be addressing the substance of the Virginia law, and I'll be pointing out some of the ways that it is similar to and different from the laws we already have in California and the EU. So I'll turn it over to Austin.
Great, thanks, Marie. As Marie mentioned, the Virginia Consumer Data Protection Act was just signed yesterday. We just had to update this slide. It was passed about 2 weeks ago by the Virginia General Assembly and is now officially going to be a law. It does not take effect until January 1st of 2023, but there's a lot to cover and be prepared for and learn about. In some ways, it's very nice that it actually goes into effect the same day as the CPRA in California that amends the CCPA. So hopefully as you're preparing to transition to the CPRA compliance, you can also keep this stuff in mind. So the Vcdpa, as we'll be calling it, has a kind of unique mix of privacy concepts from the CCPA, the GDPR, and sort of its own takes on a few things. The big kind of takeaway is that usually most of the provisions are somewhat easier to comply with for businesses than the CCPA, not quite as much micromanaging of all the details, but there are a few key issues where the Vcdpa definitely has new requirements that aren't in the CCPA or more burdensome requirements. So we'll be covering all of those. We'll jump right into it, and just for little visual cues, for slides that are about the Vcdpa, it'll have this little Virginia icon in the corner, and similarly for California and the EU, we'll have those hopefully so that that stays very clear. But the scope of the Vcdpa, we'll start with what businesses are covered. There are two key thresholds for the Vcdpa to apply to a business. If a company is controlling or processing the personal data of 100,000 or more Virginia residents in any calendar year, the Vcdpa will apply. Or if you're processing the personal data or controlling the personal data of 25,000 or more Virginians, and you're deriving 50% or more of your gross revenue from the sale of personal data, then it will also apply. So lower number there, but if your primary business is selling personal information, it'll apply. And we'll get into the definition of sale because that's different from the CCPA, of course. And then there are two categorical exceptions that are interesting for the Vcdpa. Any organization that's covered by HIPAA or the Gramm-Leach-Bliley Act, which is for financial institutions, are completely exempt from the Vcdpa, which is interesting. And Marie and I were talking, it could be a potential drafting error just because it's peculiar to completely exempt those entities, even though they certainly have information that isn't itself subject to HIPAA or GLBA. So might be something to keep an eye on. And then just nonprofits and institutes of higher education are exempt as well. But that's kind of what the businesses are subject to the Vcdpa, and Marie can talk about some other jurisdictions.
Yes, so for those of you who are already complying with these other laws or who are potentially going to start working on compliance, There's some similarities that we see right here between the CCPA, which is this slide, we'll do GDPR next, between the CCPA and CPRA. For those who aren't familiar, we're going to have so many acronyms today. We'll try to keep reminding you what each one means. So CCPA is the current California privacy law that we're under right now. And in 2023, like Austin mentioned, some amendments to it, which are referred to as the CPRA, go into effect, which will have some significant changes for California privacy law. So currently, as with the Virginia law, you see exemptions under both the CCPA and the CPRA for nonprofit organizations. There are ways that they can become controlled by the laws, but as a general rule, they're exempt. Government agencies are also exempt from these requirements. There's no special rule for institutes of higher education. So if you're a nonprofit institute of higher ed, you get the nonprofit exemption. But if you're a for-profit, then there's no exemption that applies. So then what we have is a set of thresholds similar to the ones that you saw for the Virginia law. So in Virginia, it's controlling or processing the data of 100,000 or more Virginians. In California, that number is going to be 50,000 currently, 50,000 Californians, or starting in 2023, 100,000 Californians. So you have some Californians data if you have at least that many, or if your gross revenue is over $25 million and you have any Californians information, it would also apply to you. Third option, you not only have the information of California residents, but you earn at least half of your annual revenue by selling it. The CPRA will amend that so that it applies to the selling or sharing of Californians' data. So if you earn at least half of your revenue by selling or sharing Californians' data, the CCPA/CPRA will apply to you at that point. CPRA has also introduced some new clarifications. If you're part of a joint venture, if any member of the joint venture or partnership that controls at least a 40% interest is itself subject to California privacy law, then the joint venture or partnership becomes subject to the privacy law. So again, like we see a lot of similarities here, but also some differences. There's no general exemption for organizations that handle HIPAA protected or GLBA protected data. You instead see exemptions for the data that's covered, but not for the organization as a whole. And then we'll move into looking at Europe. So under the GDPR, which is Europe's general privacy law, nonprofits are covered, they're not exempt. Europe is, as a general rule, going to have more requirements. So there's fewer exemptions. It applies essentially to everyone unless you're doing something purely for a personal or household reason. There was a lady who sent out emails to people in her church who was subject to the GDPR because she utilized the church list for a non-church reason. She wanted to talk to them about something else. It was no longer household activity because she was combining those two things. So very, very specific there. And even if you're not in the EU, if you offer goods and services to people in the EU, the GDPR can apply to you if you monitor the online behavior of people in the EU. So that's like cookies, tracking data on your websites, the GDPR can apply to you. So again, like much more broadly applicable in terms of jurisdictional reach for the GDPR than we see in both the California and the Virginia rules.
And so I think the key takeaway with how Virginia is different from the CCPA in particular is that threshold of $25 million gross revenue just doesn't exist. So in California, even if you have 10 Californians data, if you're a big company that makes more than $25 million, you're subject to it. But in Virginia, it's only based on numbers and potentially how much money you make from selling data. So going into what data is covered, the basic fundamental building block of the Vcdpa is personal data, which is any information that is linked or reasonably linkable to an identified or identifiable natural person. It's kind of refreshing that it's just a very short basic definition. It doesn't have the like 13 or whatever categories that the CCPA breaks it down into. The other key thing here with the VCDPA is that business-to-business information and employee data are not included in under the law. Specifically, those people who you contact as part of your business or who you employ are just not considered consumers under the Virginia law. So that is a key difference that I think businesses will really appreciate, not having to deal with all of that. There are two subcategories of personal data. There's pseudonymous data, and we'll get into the definitions of these in depth a little bit later on. But if it's pseudonymous, then there are fewer obligations, but it's still personal data. And if there's sensitive data, then there are more obligations and requirements around it. And then just to note that personal data doesn't include de-identified data. Note that that's separate from pseudonymous data, so that's a little bit confusing. But personal data also does not include publicly available information, which is generally stuff that is shared with the public. Pretty straightforward. And then, as Marie mentioned, like under the CCPA, data regulated by a bunch of federal privacy laws, most notably HIPAA, the FCRA, Fair Credit Reporting Act, and FERPA for educational information. That data is exempt, but if you're a company that deals with FCRA data, credit reporting data, and you have marketing data or cookies, things like that, that other data that's not subject to the FCRA will still apply, will still be covered by this new Virginia law.
So yeah, so that's a really clear connection that we see with the CCPA and the CPRA. Again, if you have a federal law that's protecting the data already, that data remains protected by the federal legal regime, and the CDPA, the CCPA, the CPRA don't try to intrude on that. The definition of personal information is a little bit different under the CCPA, but still close enough. The main difference is that the CCPA specifically says it's information that could be linked to an individual or household. So that household piece does lead to some confusion oftentimes in California when you have to decide, you know, is this information, while not linked to a specific person, does it, you know, make it pretty clear that it's a member of this household? And then whose permission do we have to give if we receive a privacy request? And typically the answer is everybody in the household if it's household information. So there's one thing to note about California. CCPA, let's just start from the premise that they were the first ones to do this in the US, and they didn't have the ability to look back at much in terms of where to draw from other than Europe's law, and they were trying not to go as far as Europe. So I'll just say there's some drafting issues with the CCPA that I think Virginia's done better. And some of those relate to aggregate and de-identified consumer data. Those things aren't included in data that's covered by the CCPA, but there has been some confusion among different groups about what does that mean? Is pseudonymous data included in aggregate information? So we're going to go into that in a little bit more detail in a few minutes. One thing also that is exempted, like Virginia, is publicly available information. So that's things that are coming from your federal and state local government records. And then finally, there's a business to business and employee exemption under both the CCPA and the CPRA. It's time limited, currently set to expire in 2023, most likely going to be extended. But personal information that you collect in that business to business contact, you know, your contact at, you know, your partner company or your own employees' data is for the most part exempt. You do still have to protect it from a security perspective. If there's security breaches, you're liable under the rules, and you have to give them notice about what you're doing with their data, but you don't have to fulfill all the other parts of the CCPA regarding that information. So that is one like very specific California kind of approach to employee and business to business data that we don't see in either Virginia really or the GDPR. So the GDPR approach is that personal information, one thing that they're really clear about is it's only for people who are alive. So have fun with the information of deceased people. The GDPR doesn't touch it. But it's anybody who's directly or indirectly identified. So this is an expansion in a way that neither Virginia nor California does. In Europe, if you have data that could, from your records not identify someone, but if you added an outside record could identify someone, that data is susceptible to the GDPR. A good example here is pseudonymous data. I struggle with that word. If, say, inside your organization, you do not have a key to the data, but an outside organization, maybe that you bought the data from, does, that information is identifiable under the GDPR, even though your organization alone couldn't identify the individuals in the data set. So keep that in mind. It's more broad in that sense. That's, to me, the main differentiator between those. And they do not have any business to business or employment exemptions. So again, your employees could be sending you privacy requests out of the EU, which is something that we really struggle with in the United States because it's a different way of thinking about employee data, and something that we don't see in the same way in Virginia.
So just to dive in quickly into those specific categories of data that Virginia regulates, de-identified data is pretty much similar to the CCPA. It's any data that you can't reasonably link to an individual. And in addition to not being able to reasonably link it, you also have to take reasonable measures to ensure it can't be linked to anyone in the future. You have to publicly commit to keeping it de-identified. And you have to contractually obligate any recipients of that data to comply with Virginia's law. That contractual requirement is worded very broadly to say that they have to comply with all provisions of the Vcdpa, which doesn't make a lot of sense. So presumably that is requiring them to comply with those same provisions about de-identified data, not re-identifying it, that kind of thing. But it is worded very broadly, so something to keep an eye on that hopefully we'll get some clarification. Publicly available information is broader than the current CCPA definition that Marie mentioned. It includes government records, but also any widely distributed information to the public, specifically like anything that's printed in the news media or that a consumer themselves publicly shared. Pseudonymous data is data that isn't linked to anyone currently, but it could be given other information that is maintained separately. And the VCDPA requires that you have organizational and technical measures in place to keep that pseudonymous data pseudonymous as long as it should be. So information that, as Marie mentioned, if someone else has the key to decrypt the personally identifiable information in it, that could be potentially, even if it's within your organization, but that key information to unlock the pseudonymous data is kept sufficiently separate. That could be pseudonymous, but a separate category from de-identified. And the VCDPA has a special category for sensitive data, which is a few of the classic protected characteristics like race, ethnicity, religion, health diagnoses, which might be less broad than just general health data. That's a little unclear. Sexual orientation, and also citizenship and immigration status are covered. And then there's a category for biometric data used to identify people, and known children's data. So if they're under 13, that's considered sensitive data, and precise geolocation data, which is defined as within 1,750 feet, which, if you can't do the quick math, thanks, not metric system, is about a third of a mile.
Do the quick math.
I'm sure everyone was dividing that by 5,280, but within about a third of a mile. So those are the special categories of data that Virginia has specific requirements around, or different requirements around. And Marie can talk a bit about how that compares.
Yeah, so I'll start actually where you ended with the sensitive information category. The CCPA, this is a failing that we had in the CCPA when it came out in California, where it didn't really address particularly sensitive information. So what we're going to see instead is the CPRA has given us a category and a description of sensitive information with some additional requirements for protection of sensitive info. So that'll come into effect under the CPRA. It's really similar in the way that it's defined in Virginia. There are some differences. In some ways it's more broad, and in some ways it's more narrow. So for example, the sensitive data category in California doesn't touch on children's data specifically. It does in Virginia. It does match in other areas like precise geolocation within a third of a mile, race, ethnicity, religion, sexual orientation. But there's some other places where the CPRA is more broad. For example, health data, not health diagnoses. And it also specifically protects sex life information, not just sexual orientation information. So there's some differences there where the CPRA goes further. And then also another difference that we see is Virginia specifically addresses immigration status as a piece of sensitive data, whereas California does not. So again, there's a number of different ways that we might be collecting all of those categories of data or inferring them, and they will have to be treated with increased protections starting in 2023 if you're looking at California or Virginia. I'm actually going to skip to the next slide and then come back if you don't mind, Austin, just while we're talking about sensitive info. The GDPR, if you look at the bottom of this slide, it says Article 9 special categories. So they don't use the word sensitive information the same way, but it's the same idea. If you have special category data, race, ethnicity, political opinion, religious and philosophical belief, they add in specifically trade union membership. It's a very important issue in the EU, and some other issues. These are all considered special categories. So they match up pretty closely with sensitive information and the other two laws. And again, there's increased restrictions around what you can and can't do with that data. So let's just go back, sorry, one slide really quickly to hit on some more California stuff. I think just some of the most important things to think about when you're looking at similarities and differences here is, again, de-identified data. One thing that we now see coming out of California is what we'll call a harmonized definition. If you're a HIPAA covered entity, their definition of de-identified has been incorporated in so that you can treat them the same. There's a second definition of de-identified information in California for those that aren't using the HIPAA definition. And so just keeping that in mind, they've incorporated two different definitions for two different scenarios. The second one matters the most because there's far more organizations that are not covered by HIPAA than that are. So the second definition is the one that most companies who are on the call today will need to pay attention to. Most important thing being for that data, you have to implement safeguards around it to prohibit re-identifying it if you have de-identified it. And then again, with pseudonymized data, just the idea that you, again, like with de-identified data, have to have technical and organizational measures around that data so that it cannot be identified, if it cannot be decrypted, if it's been done through decryption or, through pseudonyms, whatever way you've done it. So very similar in those ways. But we do see as we move back to the GDPR, some more specific rules regarding these types of data, the special categories. So keep in mind, we said special at the top of the slide, but special has a special meaning in Europe. So there is that. Just keeping in mind for the most part with GDPR, if you're following these different jurisdictional rules, that if you're looking at publicly available data, this is what I wanted to focus on this slide, some aspects of GDPR apply in Europe. So with California and Virginia, publicly available data isn't covered. But under GDPR, there are certain parts of the data privacy regime that will apply, including notice. So if you get an individual's information through a publicly available source, like property record search, you still have a notice requirement where you have to give that individual notice that you have their data and that you're about to process it for whatever purpose you're going to process. So that's really different than what you see in any of the US jurisdictions right now.
That's right. So how the Virginia law specifically regulates personal data, the key issues are sales of personal data, targeted advertising, and profiling. Sales, the best part maybe of the Virginia law, in my opinion, is that sales is defined in a way that makes sense to a layperson. It's just exchanging personal data for monetary consideration by a controller to a third party, anyone else. So that's straightforward, makes sense. Targeted advertising is basically showing any ads based on personal data that's been attained from someone's activities over different time periods, especially with non-affiliated websites or any online applications, in order to predict their preferences or interests to show them ads based on that. Notably, it doesn't include showing ads based on a consumer's history on your own website. So if you're serving personalized ads because you know this person has bought product A from you in the past and product B is a really good complement to that, that is not targeted advertising under this law. It's only when the data has been obtained from other unaffiliated websites or as we discussed before, or like the immediate context, such as if they search for something on your website and you say, oh, well, let's show them something based on that current search term, that also is not considered targeted advertising. So it's, I think, a relatively balanced approach to generally what we think of as targeted advertising, with some carve-outs for things that are less sensitive, generally considered. Profiling is any automated processing to basically try to figure out someone's how much money they have, their health, any personal preferences, hobbies, how likely they are to continue shopping with you or whatever it is, their location or movements, anything like that that you're trying to infer based on prior activity is considered profiling. Not all profiling is necessarily bad or particularly subject to new restrictions under the law. It's only kind of profiling for sort of serious things. We'll get into that a little bit more later on, but that's the general definition of profiling. And just one other thing to note is that in general, there is a data minimization requirement, meaning you can't collect or process more information than is reasonably necessary to provide whatever service or product or whatever you're giving.
Yeah, and kind of the takeaway there is that data minimization is coming to a jurisdiction near you in 2023, right?
Yeah.
Because whether it's through Virginia or California or the EU, by then they'll all have that rule in place. Right now, the EU already has it in place, but the CPRA will amend California's law to include it in 2023 as well. So that's really the thing that probably has set US privacy law apart from European law until now. The idea, and I noticed that somebody was commenting on this in the chat earlier, that US privacy law is generally described as permissive. It's allowed unless it's forbidden, and EU law is described as prohibited. Things are forbidden unless they're specifically allowed, which is generally the way I think it has been described by everybody in the space for a long time. But these new data minimization requirements being introduced into US jurisdictions do kind of show the sea change that we're seeing in the privacy space that was let out in Europe, but is now being adopted in more and more jurisdictions around the world, not just in the United States. So what does that mean for you? Well, my top point on this slide is just consider everything regulated by the GDPR. If you're in doubt, it's probably covered. And the activity that you want to engage in with the protected data is probably regulated in some way. It doesn't mean you can't engage in the activity, but there's probably at a minimum some process requirements, some record keeping that you have to do in order for it to be allowed. So that's just sort of the right approach to the GDPR. So there's that. A difference that you see though in California that's different than both Virginia and the EU is that under the CCPA, the sale of personal data is the sale not just for money. So Virginia is like the monetary consideration in exchange for data is a sale. In California, it's monetary or any other valuable consideration. So for example, if you're trading data with an affiliate or a partner and you give them a data set and they share a data set with you, or you're part of sort of a co-op of that shares data, I've worked with a few of those in the past, that is exchanged for valuable consideration. The data itself is valuable. So your definition of sale is more broad in California than you see in Virginia. Starting with the CPRA, California will also have a requirement that sharing or selling personal data is an activity that users have to be able to opt out of. Right now, you only have to allow them the option to opt out of the sale of their data, but sharing or selling. So if you're, I saw somebody also in the chat commented that they're a service provider. As a service provider, if somebody's sharing data with you, that sharing becomes more regulated starting in 2023. So those are some of, I think, the key differences. We also see, like Virginia, in California, some rules regarding cross-context behavioral advertising, which is taking the data from one use or from multiple websites and putting it together. Essentially, what you're doing in that situation is a type of profiling, and that becomes very heavily regulated and not allowed for service providers in the CPRA context in 2023. So those are some of the main highlights for both Europe and California on this side. I will say though, just like as an additional note, profiling and automated decision making sometimes are the same thing, but sometimes are not. Under the GDPR, if you engage in any decision making that's automated, so a credit check and the outcome determines whether somebody does or does not receive a loan, or a criminal history background check and the outcome determines whether somebody does or does not receive a job, that's considered very suspect in Europe. And so you have to engage in what's called a DPIA, a data protection impact assessment, to basically go through the process of balancing the risk. And part of the risk is the risk to the person's right? So their right to privacy, their right to employment, their right to housing, their right to whatever it is you're offering, against your interests in engaging in the process. So there's a lot of protections that have been built into the GDPR that we're starting to see Virginia and California mimic, not to the same scale with like record keeping requirements. It's very much lower in Virginia and California, but they are, I think, coming.
That's right. So this slide I don't want to spend a ton of time on. Most of the consumer rights are pretty similar to the CCPA and to a decent extent the GDPR. Classics like access, deletion, portability, also adds correction, which isn't currently in the CCPA, but will be in 2023. The opt-out right extends to sales of personal data, which again is in Virginia only giving data for money, but also for targeted advertising, which, as we discussed before, has some exceptions if it's on your own site, using only data from your own site, or immediate context, and profiling. Profiling that is, quote, in furtherance of decisions that produce legal or similarly significant effects concerning the consumer. And that in turn is defined as a general rule. It's basically profiling that has significant effects. So that kind of profiling isn't prohibited, but consumers can opt out of it. So if it's going to be something like profiling that will determine whether someone gets credit or employment, healthcare, access to basic necessities, even they say, housing, things like that, then it's something that consumers can opt out of. And one other interesting note about Virginia is that controllers are permitted to actually charge different prices or potentially give fewer services or things like that if consumers opt out, or in general for loyalty programs. So that is something that is unique to Virginia, explicitly saying, look, if someone opts out of some of these things, then it may be appropriate to not give them discounts or certain things like that. So that's definitely something to watch and kind of a key differentiator when it comes to consumer rights in Virginia. Also, if you're getting a portable copy that's technically limited just to information the consumer provided. And similar to the CCPA, there's a 45 deadline for responses with another 45-day extension. So most of that, again, is not super new, but I think that key opt-out issue, especially for charging different prices, is definitely something to keep an eye on.
Yeah, and that's something that we've seen a lot of questions around in California specifically because there is language in the CCPA about loyalty programs, but it was really unclear. There were a lot of questions around it, and so we see in the CPRA, the amendment that goes into effect in 2023, clarified language around loyalty programs, like making it very clear that you can still operate those. But one thing that the California regime does differently, and that we've seen some rulemaking around, or at least some advisory rulemaking around from the Attorney General, is that if you're running a loyalty program or some kind of discount where you offer, you know, a discount or some other consideration exchange for people's data. So like sign up, give us your email address and you'll get a 15% discount on this purchase or whatever it is. Um, you're allowed to run them, but you have to have the value of the discount be in some way related to the value of the data itself. And so that's been really confusing to a lot of people because we've, for the most part, never had to assign a specific value to this kind of data. It's kind of a thing where, you know, at a lot of companies, you ask the marketing team, well, we want to increase sales. We want to get new customers in the door. So they start coming back to us because they like us. How do we do that? And they're like, oh, well, you know, let's run a 15% discount. And that's all the thought that went into it. Like we can survive a 15% discount. So let's offer it. Now you're having to sort of sit down and say, well, how much is this data worth to us? Are we offering a differentiation in service that's really related to the value of that data? And that's the issue. The underlying issue here is discrimination. So if people are exercising their privacy rights, they have the right not to be discriminated against. So I said, you know, don't sell my data. And you said, okay, but things are going to cost you 15% more, you know? And so the consumer's sitting there going, that's not fair. So you have to really start to create a trail of documentation for how you determine value and how you decide what discounts to apply and how you determine that you are being equitable, essentially. And there's rules from the Attorney General around that. Sort of related to that, I'll just say quickly, the GDPR doesn't touch on this as specifically, but one of the reasons that it doesn't is because GDPR is an opt-in regime, whereas CCPA and Virginia are more opt-out regimes where it's like, you can do anything you want with our data unless we tell you not to. GDPR, it's like, you can't ask for data unless people are consenting and opting in to certain programs. So it's just a really different approach to these types of incentives, well, to everything. So just a few other things that are different. Data portability, you don't have under the CCPA right now. You do have the requirement that if somebody asks for a report of the data you have to give it to them in a readable, portable format. But starting under the CPRA, it will be that if they ask you to send specific pieces of personal information to another entity, that if it's to the extent it's technically feasible, you would have to do that, and you'd have to do it in a structured, commonly used, like machine readable format. So if you're an organization that you know, you create photo books for people, and so people upload their photos to you, and somebody sends you a portability request and says, send all my photos to Facebook. It's usually going to happen the opposite direction, right? Everybody's trying to leave right now because of all the stuff going on, or whatever organization it is. It could be anything that you would have to, insofar as it's feasible, pull their data out and send it to that third party in a way that that third party could actually use. So that could get really technical. It's something we see in the GDPR. So we'll just move over to the GDPR slide, I think. And so with GDPR, portability is one of the major aspects of it. It's one of the complaints that you see a lot of times from individuals in terms of like they want their data out of whatever platform they've been using. But as we all know, your platform is specific and it's specialized, and getting it out into some other format can be really difficult. So if you don't have procedures in place to do that sort of thing, this is a good time to start planning it, because you will start seeing portability requests increase. They're already happening in the EU. We're going to start seeing them more and more in the US in 2023. Um, the EU's list of rights is a little bit longer in terms of what consumers can ask for. One of the main things that we see is the right to rectification. We don't currently see that in uh, California, but like Austin said, we're seeing it in Virginia, and starting in 2023, we will see that in California as well. So people can ask that you correct their data if they think you have bad data. You do have the right to disagree with them. So some of data that you have may be opinion data, inference data that you build based on the other things you know about them. So basically, you have to have a process in place to either correct the data when they ask you to, or to document why you are going to keep what they consider to be inaccurate data. So it's a really interesting push-pull depending on what type of business you're in. Or may not be as important to you. If you're correcting somebody's shipping address, pretty simple. But if you're correcting something like, a notation that you made that you think this person's a bad credit risk, really different. Different ways that you have to start treating data and documenting your decisions about how to treat the data. Sorry, one last thing is GDPR has a 1-month response time, whereas Virginia and California have 45 days, so a little bit shorter, but you do get to toll the time. So if you send them a verification request, it's like, okay, well, to do that, we need you to answer these 3 questions so we know it's really you, and they don't respond for a week, you can take a toll for a week of your time and say, like, that time doesn't count against me. So they're really clear about that in a way that I would like to see US jurisdictions do.
Yeah. So in the Virginia law, one of the first notification or requirements for businesses is notification. The law requires that controllers provide a privacy notice, which tells you what categories of personal data there are, why it's being processed, how they can exercise consumer rights, like the access, deletion, and that, what categories of personal data are being shared with other organizations, and the categories of third parties with which the personal data is being shared. Now, this isn't, these first 5 aren't taken verbatim from the law, but are actually pretty close. It's really nice to just have, for businesses, to just have, okay, do these general things and not have to, have paragraphs and paragraphs of what each one means and how to handle every specific edge case. So I think that's something that businesses will appreciate about their notice obligations in Virginia. They're pretty high level, like you have to do those 5 things, but not every nit has been picked. And then the last thing is also the notice has to give clear and conspicuous disclosure of any sales or targeted advertising that the company does. And the law doesn't actually include clear and conspicuous disclosure of profiling, which might also be an oversight, since sales and targeted advertising are things that you can opt out of, and profiling is as well. So it would make sense for a requirement to be there to disclose profiling in the same way. But in general, those notice requirements are pretty high level, pretty fundamental, and not a lot of unnecessary detail.
Yeah, and I would just say that in general, California's are similar, like 1 through 5 match pretty closely. And 6 is kind of new, but I think we'll see California mimic that soon. GDPR has a really long list that gets really confusing, which is hard because part of their rule is that you have to have your notice in like easily understandable terms, but then they give you all these requirements. So what I've done is I've put those into a note on the slide deck. You can review them because me just saying them out loud is not going to help you remember them.
Yep. And also just one other kind of generic controller obligation I neglected to mention in Virginia is that there are basic security requirements. Pretty much you have to have reasonable security. And I know, again, there was a question about service providers under the Virginia law. And one of the biggest changes from the CCPA is that there are a number of basically GDPR-like requirements between controllers and processors. So things like not just that service providers can't sell data, which is one of the main things that California requires, but also that service providers affirmatively help the controller comply with its obligations, allow for provide documentation that they're actually complying and things like that, things that are generally more GDPR-esque. So that'll be something that definitely applies between controllers and processors. A brief overview of how Virginia handles consumer requests that come in. So again, these are things like access, deletion, opting out, that kind of thing. The privacy notice has to outline one or more secure and reliable means to submit those rights requests, no more detail than that, and gives kind of high-level guidance that it needs to take into account how the consumers interact with the controller normally, making sure that, of course, it's secure and reliable, and the ability to authenticate that the person is who they say they are. And one thing that's new in the Virginia law from the CCPA is that there is explicitly a appeal requirement that you have to explain if if a consumer disagrees with their request to delete information, they have to be able to appeal it within your company and say, no, I think it really needs to be deleted because XYZ. And there's a 60-day deadline to reply to one of those appeals. And the appeals process can't be like a whole new thing, very dissimilar from submitting an initial request. And if you deny their appeal, you then have to give them contact information for the Attorney General, who they can contact if they still really disagree. So that's interesting. That's definitely new there.
Yeah, and I would say California and Europe don't have an appeal process that's specific in that way, but they do both have rules around, in certain types of responses where you're telling somebody just like a flat no, or you're saying like, well, we'll do a little bit of what you asked, but not all of it. Like we'll delete some, but not everything. In those situations, there are rules regarding like, when you send your answer, you have to also inform them of the following things. And so like, the basis of your denial and, how to, get more information, how to reach out to the Attorney General or to, in Europe, the supervisory authority. And Europe has additional rules around, what you have to tell them in any response, because what you might think is a valid response, they may disagree with, and they have the right to disagree and to go forward and lodge a complaint or to file a lawsuit against you. And that is one of the big differences too, is, on the right of action side, we see differences in this process where that type of right might kick in, where somebody might decide to bring a lawsuit.
Yep. So that appeal issue is something kind of unique to Virginia, at least in the United States for sure. And one of the biggest takeaways for the Virginia law that companies really need to pay attention to is, again, going back to that idea that US laws are generally permissive. You can usually do whatever you want unless a law prohibits it. And the EU is the opposite. You can't do anything unless the law allows it. The Virginia law kind of splits the baby on that. And for sensitive data, it is opt-in. So you cannot process sensitive data, which again is those kind of some of the protected classes, biometric data, children's data, precise geolocation data. You can't process, collect, use any of that without consent from the consumer. And consent means a clear affirmative act. There's a freely given, specific, informed, and unambiguous agreement to process that personal data. Very similar, almost verbatim definition there for consent with the GDPR. So it has to, you really have to tell them what's happening, why you're using this, that kind of thing. And they have to affirmatively say, yes, you can collect or use this sensitive personal data. And also for children's sensitive data, the requirement is actually that you just need to comply with COPPA, the Children's Online Privacy Protection Act. I believe that's the correct acronym there. So COPPA has its own requirements for getting parental consent for processing children's data. And for purposes of the Virginia law, again, a child is anyone under 13, which matches COPPA.
Yeah, and that's another place where I think we'll see some change in California to try and also become more reflective of COPPA, just because it would be easier. The approach they have right now is sort of required some back and forth on the rulemaking side already, and also some amendments. One of the interesting amendments is that children's data is subject to higher fines in California if you do mess up. But I would just say here on this that one of the interesting things is, as we mentioned before, the CCPA doesn't address sensitive data, but under the CPRA, it's not quite as onerous as Virginia. But what you have is you have a process where opt-in is required, not for any processing of people sensitive data, but for any processing that will involve the sharing of their data or the selling of it. So if you're processing everything solely internally, you could do that without them opting in. But if you use any, service providers that you're sharing the data with, which most people do, then you'd be in a situation where you would need them to opt in. In GDPR, I will just say, like, again, on the slide deck, we've got some really deep notes for you on GDPR because they have a set of really rigorous rules around the processing of this data and what sort of record keeping and other requirements you have to meet before you can engage in the processing of the data. So.
Yep. And then the, I think, other biggest takeaway for the Virginia law that's coming up is data protection assessments. As Marie mentioned, data minimization requirements are coming to the US through Virginia and the CPRA, and data protection assessments are also coming to the US for the first time officially in Virginia. These, if you're familiar with GDPR, you'll know, I think they call them data privacy impact assessments or something slightly different. But
yep.
The general idea is that there are reports that controllers have to do in certain situations. Specifically in Virginia, whenever you're processing personal data for targeted advertising, whenever you're selling personal data, whenever you're profiling consumers in a way that presents a reasonably foreseeable risk of negative impact on them, which is slightly different actually from the opt-out right, which is interesting, but same general idea if you're going to be doing anything that could really negatively hurt them. This one specifically mentions like reputational harm, for example. But if you're doing that kind of profiling, that's when you need to do one of these assessments also. Whenever you're processing sensitive data, no matter what you're doing with it, you need to do one of these. And whenever processing kind of a catch-all involves a heightened risk of harm to consumers. So that's going to be kind of a big deal for companies to have to affirmatively do those in that situation. The assessment itself is basically kind of an internal documentation requirement where a company specifically weighs the benefits that go to both the controller, the company, the consumer themselves, and the public potentially. Any benefits that accrue to those people against the risk to the consumer. And you can, of course, take into account any mitigating factors like whatever encryption or organizational measures you have to prevent risks of harm, things like that. But you need to weigh all of those, take them into account, and come to a determination about how those shake out. It does allow for reuse of assessments that are done to comply with other jurisdictions, which right now is primarily going to be the EU. So potentially, if you are already doing these for GDPR compliance, as long as they're comparable in scope and things like that, then you may be able to reuse those for Virginia so that they don't want to make you redo the same work for them. And one other thing to note here is that these assessments, which are kind of inherently going to contain some sensitive information about how you see risks to consumers, the Virginia does want those to be able to be very candid and thorough, and so companies do not have to make them public. And while the Attorney General can access them during investigations into violations of the law, even then they won't be subject to FOIA requests or anything like that from the Attorney General's office. So they do want to give some good assurances that these things do not need to be made public.
Which is probably the main difference in the approach that we see in US regimes in Europe. That focus on the privacy of the company is definitely a lot stronger in the US, which is why we've seen recently pushback coming from Europe with the ability for companies in the US to process European data. So if you're following GDPR, we have a separate series that talks about things like upcoming changes to the way that you do data transfers out of Europe into the US of personal information. But that's another topic. But on this side, I just thought that I would note, we don't see any sort of risk assessment requirements under the CCPA, but we do see them coming in 2023 with the CPRA. It won't be something that everybody has to do. Essentially, if you engage in high risk data processing, you will be subject to annual audit requirements and regular risk assessments that have to be submitted to the Attorney General. That's really all we know right now, though, because the amendment itself, the CPRA, says this is going to be subject to more rulemaking. The AG or the California Privacy Protection Agency, which we're creating right now, will be in charge of setting up those rules to determine who is high risk, how do they submit these reports, what has to be included in it. So we'll see more on the rulemaking side coming out of California in the next 2 years. And I don't know, Austin, is there like a similar rulemaking um, requirement that we see in Virginia's law right now?
Yeah, that's a very interesting distinction, is that Virginia does not have any instructions to the Attorney General or anyone else to create any regulations, whereas California, especially the CPRA, gives, I think, like 20 paragraphs of topics that the AG needs to regulate on, and Virginia is not envisioning any regulations. So as it stands now, it's just the law and that's it. That being said, the Virginia law does create a working group consisting of the AG, a few state officials like the Secretary of Commerce, and will include business representatives, consumer rights representatives, who by November 1st of this year need to give a report with their kind of findings, their thoughts on the law, recommendations, and that kind of thing. So that could spur the legislature to amend the law, but there are no direct regulations envisioned or anything like that.
And I would say, sorry, I was just going to say that's actually really reflective of Europe again, with the working group that advises and sort of is the starting point for most of the changes we see to GDPR's rules and regulations. And in this space, as previously mentioned, like there's a lot of requirements around impact assessments under the GDPR for high risk activities. And so we have, like I said, that really long note in the slide deck for you to give you some guidance on that.
Yep. And so those are the two biggest headline issues with the Virginia law: the opt-in for processing sensitive data and data protection assessments. Just as we end the hour, we have two quick slides on enforcement. In Virginia, it's quite similar to the CCPA, actually no private right of action, AG enforcement only. Fines do go up to $7,500 per violation. And there's still a 30-day cure period, which is currently in the CCPA, but sort of going away in 2023. But nothing too different there.
Yeah, I would just say the main difference is that there's just a limited private right of action in California, where for example, if there's a data breach, an individual could bring a lawsuit against an organization under the CCPA. We've already seen some really interesting litigation strategies where people are using that to shoehorn into a class action attempt. We haven't seen one of them succeed yet. We'll see if that does happen. GDPR also does have a private right of action to seek compensation for both material and non-material damages. So in US speak, we call that actual damages for the material side. Non-material is sort of like your more amorphous, like reputational harm that maybe can't be quantified as easily. Or even, where we see in the US, like it's $100 to $750 a pop. If it's, sort of small and you can't really quantify it. That could also fall in under the non-material definition in the EU. We do see, though, the potential for really high damages, I would say in all cases, especially considering that in the past, you weren't looking at this as a risk area where you could be looking at fines in addition to potential lawsuits. So again, like we've sort of highlighted the main differences here in the total risk that you might be looking at. I think we'll see sort of a slow ramp up in Virginia, the way we saw in California. This year, we saw some letters come from the AG warning people to get their ducks in a row, but no real fines. Part of that might also be attributed to COVID. But I think we'll see the Virginia team be more ready to take action sooner because of the history that we've already had with California and with the GDPR. Okay, so on that note, we're going to call it a wrap. We're just past the hour. There are some questions in the Q&A that we weren't able to address during the presentation. We will be addressing those in follow-up email. So if it's in the Q&A, we will do our best to respond. And as previously mentioned, if you are looking for the materials, that you'll receive an email that has both a recording as well as a copy of the slide deck. So we really appreciate your time with us. If you're looking for a privacy solution, we do have CCPA and GDPR solutions available at SixFifty, and we're creating our Virginia solution. It'll be ready to go well in advance of the time that the law goes into effect. So thank you so much for your time. We appreciate it.